With that, I will call for argument the first case on the morning docket, case number 119720, State of Kansas versus Richie Randall, Jr.
Again, I'm Rick Kittle. I represent Mr. Randall, and I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
This case comes to the court on direct appeal after Mr. Randall's conviction at a jury trial of first-degree murder and criminal discharge of a firearm at a dwelling. Regarding the substantive facts of the case, I would just say that the state's evidence indicated in this case that 3 men, including Mr. Randall, went to an apartment complex in Wichita and standing on a landing or a walkway outside one of the apartments fired multiple gunshots into the apartment through the front window, the front wall, and the door of the apartment. The occupant of the apartment, a man named Timothy Golden, was killed by gunshot wounds.
Was he sitting on the sofa at the time? Is that what the scene photographs indicated?
I don't think so. The facts of the case indicate that after the shooting, other residents of the apartment complex went into the apartment. They had to break down the front door to get inside, and his body was found lying on the kitchen floor.
Okay.
And there's video evidence of that.
And I had difficulty from the record really determining the physical layout of that. So from the front windows or where the shots were fired, where was he? Kind of in general. I
think from the front window, what is behind that front window is a living area, and then adjacent to that off to, my recollection of looking at these photographs and the video particularly is, if you're looking at the front of the apartment, you have the living area, then off behind that to the right is where the kitchen is, and then behind that is the bedroom and bathroom area.
And this, of course, becomes important because of the argument of whether or not it was through the partially open blinds he was visible or not. And so that's...
Right, I understand that. And my argument on that, and that's the primary argument I have here this morning, is that there is no evidence that Mr. Randall saw anyone inside the apartment. There's no evidence that he knew that anyone was in the apartment. The blinds were down when you look at the video that was taken after the fact by law enforcement. As I stated a bit ago, there's no evidence that anyone went into the apartment just before, during, or after the shooting until the other complex residents broke down the door to go inside to see if anyone was in there, and that's when they found Mr. Golden's body on the kitchen floor.
How do you explain then the crossfire pattern that the evidence shows? You've got 3 people shooting through an apartment window with different angles, apparently to cover the whole apartment with a whole lot of bullets.
That may be the case, but my argument would be that doesn't mean that they knew anyone was inside the apartment.
And how do you account for, you say the blinds were down, implying that they were opaque and you couldn't see anything through it. And the photographs that I saw kind of indicate the blinds were, not sealed, not completely blocking the vision in there. So, they're all jumbled up, and there's clearly some, damage from all the bullets that are going through it, but there's also an indication that you might be able to see in there. So, again, isn't that evidence that a jury could infer some ability to know there's somebody in there?
Well, I don't think that's the standard. The standard on whether a lesser included offense instruction is needed is viewing the evidence in the light most favorable to the party requesting the instruction. And I think in order to come to that conclusion based upon the evidence we have, that somebody, based upon the way the blinds are configured or the cross pattern of trajectories of bullets, in order to come to the conclusion that based upon that, Mr. Randall would have known someone was in the apartment, you have to view the evidence in the light most favorable to the state, which is not what this court's standard of review is. The crime, the lesser included offense, well, I guess there are three crimes at issue here. There's the greatest crime, greatest level crime, the one that was charged, which was intentional first-degree murder. There's a lesser included offense instruction, which is intentional second-degree murder, and then there's an even lesser included offense, which is reckless second-degree murder, which is the instruction at issue in this case. There was an instruction on the lesser included offense of intentional second-degree murder. In order to, whether the defendant is entitled to a lesser included offense instruction is both a factual and a legal question. The legal questions here are, was the issue properly preserved? The state's conceded that. Is this a lesser included offense? The state has conceded that. There's case law cited in both briefs indicating that reckless second-degree murder is a lesser included offense of the charged homicide in this case. So the question then becomes factual. We've discussed some of the factual matters in this case. One of the things that I discussed in my brief is the skip rule and whether it applies in this situation. And generally speaking, the skip rule, again, applies when there are at least three crimes at issue, and we have that in this case. We have the greatest, again, intentional first-degree murder, the lesser intentional second, and the even lesser reckless second-degree murder. The skip rule says that if you have that scenario, then it's not necessarily error to refuse to give the even lesser included offense of, in this case, reckless second-degree murder if the court has, or the jury has found the defendant guilty of the greatest offense, the charged offense of intentional first-degree murder. But there is a rule for the application of the skip rule that was announced by this court in State v. Plummer, and it says the skip rule should be viewed as simply providing a route to harmlessness in those circumstances where elements of the crime of conviction, as compared to a rejected lesser included offense, necessarily show that the jury would have rejected or eliminated an even lesser offense. So if I understand that the application of that rule correctly, what you need to do is look at the two highest level crimes, intentional first-degree murder and intentional second-degree murder, and compare those. And in comparing those two, can you determine that based upon that evaluation, the jury would have necessarily rejected reckless second-degree murder? And I don't think you can do that in this case, because if you compare intentional first-degree murder and intentional second-degree murder, neither of those crimes has as one of its elements reckless conduct. So just comparing those two crimes with intentional conduct does not necessarily eliminate the possibility that in this case the jury could have returned a verdict of guilty on a reckless form of homicide.
How could they have if they found it to be an intentional act?
I don't think that's what's required here, Your Honor. You're not looking at to see, well, they found him guilty of an intentional act, so therefore they could have not found him guilty of reckless conduct. When you apply this rule, you just compare those two crimes to see if, looking at those two crimes, something in them would indicate that the jury would not have found him guilty of reckless conduct. And in this case, we do have the jury finding the defendant guilty of reckless conduct. Because in finding him guilty of criminal discharge of a firearm, they necessarily had to find beyond a reasonable doubt that the defendant acted recklessly when he fired gunshots into the apartment. And therefore, if the jury necessarily found that the defendant acted recklessly when firing gunshots and the victim died because of gunshot wounds, then it is reasonable to conclude that the jury, had it been given the opportunity, would have found the defendant guilty of some reckless form of homicide. This is not a case where it's a matter of speculation of whether the defendant acted recklessly. The jury found him guilty of a reckless act beyond a reasonable doubt. And the problem here is that the jury was never given the opportunity to consider a reckless form of homicide. Again, the skip rule should not be applied in this case because, one, there is a significant enough difference between the reckless form of homicide that was requested and the other crimes that were actually instructed upon, so that the lesser included offense of reckless second-degree murder could not be eliminated.
I'm just curious too. How do you understand how juries are typically instructed? I don't know if they would have been here to sequentially deliberate over the acts. You first consider premeditated first degree, and if you don't agree that the defendant is guilty of that, you next consider second degree. Here they wouldn't the jury have first considered premeditated first degree murder and found him guilty of that? How does your argument work that they would have considered the reckless second degree?
Well, I don't recall specifically how they were instructed in this case,
but
but
typically
I'm assuming that's
a typical scenario.
right,
Yeah.
and I'm assuming that's the way that things occurred here. As you said, consider first degree murder. If you're unable to agree on that, consider this, and so forth. In my experience, that has never been an impediment to finding error when there is a failure to give a lesser included offense instruction that was supported by the evidence. And so I don't think it makes any difference that the jury is instructed to sequentially consider these things if that's the case if that's the case here, because the law indicates that the jury is entitled and the court is obligated to give instructions that are supported by the evidence. And yes, a jury might be instructed to consider these in sequential order, but that doesn't mean the jury might do what it wants to do and say, look, we've already found the defendant guilty of a reckless crime here when we convicted him or found him guilty of criminal discharge of a firearm. So if we find him guilty of a reckless act associated with the discharge of the gun, and the gun was the means of the victim's death, then his homicide was the result of a reckless act as well. The jury should have been entitled to consider whether that was a possibility. And given the verdicts in this case, I think there is a real possibility that had the jury been given that opportunity, it would have returned a verdict on the reckless form of homicide, a verdict of guilty. I've got a minute left. I have other issues, but rather than embark down some other path on a different issue, I think I would try to answer any other questions the court has and submit the balance of the case on the brief that has been filed.
Other questions?
Just so I understand this, on the failure to instruct, that in that instance you view the evidence in the light most favorable to the accused, the defendant.
That's right. That's the law in the brief that I filed, and that's what the state has basically conceded.
Now, if it was error, the burden or the standard switches. If there's error and the issue is whether this was harmless or not, then you view the evidence in the light most favorable to the state, don't you?
I don't know that this is a harmless error analysis at that point, Your Honor. I think.
Well, if it was error not to instruct on this issue, then you still have to decide whether there was error, whether it was harmless.
Well, if that's what's going to apply, I think that at that point the state would be obligated to show that there was no possibility that the jury could have returned a verdict of guilty under those circumstances. But I don't think the state can show that in this situation because the jury clearly did find reckless conduct on the part of the defendant.
Thank you.
Thank you very much.
May it please the court. Assistant District Attorney Leslie Isherwood, appearing on behalf of the state. Two matters I wanted to address before I got started. Justice Lukert, with response to getting kind of a comprehensive view of the layout of the apartment, there is an exhibit that is in the record on appeal, and that states Exhibit 94, and that does provide a bird's eye view of the apartment, so it can kind of give a better layout of exactly how that residence was designed. Justice Beyer, you had asked whether the defendant was seated whether the victim was seated at the couch at the time that he was shot. And my recollection of the record is that the coroner testified that the gunshots were in kind of a downward motion, indicating that he was crouching in an effort to shield himself from the gunfire. The record will speak for itself, but that is my recollection of the testimony that came in.
Was there any evidence about blood from any other part of the apartment to the kitchen where he was found, or just?
Well, there was evidence of another gunshot to his buttocks, which they supposed was him turning to flee from the gunshots that were being fired. So the first issue before the court obviously challenges the district court's refusal to issue the requested lesser instruction for unintentional reckless second-degree murder, and there is a four-part analysis to this: preservation, whether it's legally appropriate, whether it's factually appropriate, and if error did occur, whether that error was harmless. And the inquiry before this court today focuses on the third prong of that analysis, and that is whether it was factually appropriate. And this court has told us that an unintentional, reckless second-degree murder is the killing of a human being that is not purposeful, willful, or knowing, but which results from the act performed with knowledge that the victim is in imminent danger, although death is not foreseen. Even viewing the evidence in the light most favorable to the defendant as required under the standard of review, that is not this case. What this case reflects is that these three individuals armed themselves and drove to the victim's apartment. They concealed their identities. They surrounded the only true entry and exit to this apartment. They fired at least 20 shots into this apartment. And Justice Biles, I will say that from the photographs that were admitted, that while the blinds were in a downward position, they were Venetian blinds and they were tilted into the open position, and the curtains that were available for that window were open, allowing a view into that apartment. Further, the defendant made a call from the jail indicating that he shot the victim, as well as Dakari Saunders also shot the victim. Those facts do not give rise to a reasonable conclusion that a jury would find that the defendant merely intended to place his victim in imminent danger, but that death was not foreseen. The defendant.
How does the phone call help you? Because I kind of understand the defense argument is that these guys were really just going over there to shoot up the apartment, and he just happened to be there. I mean, that's kind of the notion here. He just happened to be there, and they accidentally killed him or unintentionally killed him. So the fact that the defendant pulls the trigger, I mean, there were three guys pulling the trigger, how does that help you with getting away from the unintentional killing?
Well, I'm sorry, I didn't mean to talk over you. I would say 20 shots is very intentional. If you're intending to send a message, you can send a message with less than 20 shots in this very small apartment. Also, I think the content of that phone call, I shot him, not I shot up his apartment, or I scared him, or I frightened him. I shot him, Saunders shot him. The content of that statement is that the impact or the intention was realized through the firing of the weapon. Yes.
What do we do when we're considering this question with 5202C that says that proof of intentional conduct is also proof of reckless conduct? Does that kind of interfere?
You're taking me right where I was going.
Okay.
So the defendant argues that a reasonable conclusion or a reasonable jury would find that this was a reckless killing because they found the criminal discharge of a firearm, which contemplates a reckless act. Okay, so I think that oversimplifies what we're talking about here. Because you have reckless, maybe or maybe not, on one side, does not necessarily mean that you have reckless on the other side. So it remains the state's position that the evidence adduced at trial established that this was an intentional shooting. Well, that intentional necessarily embodies a reckless finding as well. We don't know that the jury stopped or merely found that it was reckless. The jury may have followed the state's argument that this was actually an intentional shooting. The offense does not allow for the jury to return a finding that was intentional criminal discharge of a firearm. But because they found a finding of guilt on that offense doesn't necessarily mean that they found that it was merely a reckless act.
I think that, didn't the instructions say something about it, the 5202C conduct or content?
Well, I don't know that it was.
In the instruction?
It was in the instruction.
Yeah, I
That
thought it
instruction
was.
was given that if intentional is proven, then the lesser mental states are proven. So the jury was aware of that at the time that they were considering
that's
these
what I thought.
offenses. So we don't necessarily know that they found that it was merely reckless conduct. It would be the state's position that because we.
Well, don't we actually know that at least by logical inference? In other words, would it be legally possible for the jury to conclude that the firing into the apartment was only reckless, but also find premeditated murder? Would that even be possible?
It would certainly be inconsistent.
Yeah.
Now, whether that's
Well, not just inconsistent. One would rule out the other, wouldn't it?
well, there is no other way to find criminal discharge of a firearm aside
I understand
from reckless.
that, but given the fact that we have these nesting states of mind where reckless nests entirely inside of intentional, I understand your argument to be, look, the state didn't have to prove intentional conduct with regard to the shooting. That doesn't necessarily mean the jury didn't think it was intentional, but if we look at the other charges crime, the jury found intent, right?
Yes.
And doesn't that necessarily mean that the jury also believed that the shooting was intentional?
That would be my position, yes.
And relied on that line in the instruction about intentional proving reckless?
Yes.
And given that being the law, that the proof of the greater proves the lessers, is there ever a factual inquiry about the mens rea element in a lesser included offense? If it is a lesser mens rea, or do we always have to say that it was factual, that the evidence meets the factual appropriateness of giving that lesser included offense if that is the factual question?
I'm not sure I understand your
So-
question. I'm sorry.
Is it factually appropriate simply because it is a lesser mens rea of the greater proved mens rea?
Well, I think you
does
would.
the evidence does that rule of law eliminate the factual question when we're looking at the appropriateness of a lesser included offense?
No, because I think there still has to be whether the facts would allow for a finding of that lesser included offense.
But if the facts prove the higher, the greater mens rea, doesn't, as a matter of law, it prove the lesser mens rea under that statute?
Well, I think that kind of gets us back into the proof of the greater test, or necessarily greater test, that we have tended to depart from, and we've since gone down the road of whether there are facts that would reasonably justify a conviction of the lesser offense. So I think in the current state of the law, we necessarily are bound to look at the facts and not just the legal aspect of the crime.
But another way to ask the same question, I think, is had the jury actually convicted of reckless second here, there would be no way for the defendant to argue that the evidence was insufficient for the conviction, right?
Correct.
So the evidence would be sufficient to sustain a conviction for reckless second-degree murder.
If the jury had found that.
Right.
But that is not our position here
But if
today.
the test we apply is simply sufficiency of the evidence, that presents a problem for the state, given the nature of the statute.
Well, I think you always have to look at the legal and the factual in conjunction with each other. I don't think that the legal terminology or the legal analysis can solely steer the ship.
You're arguing for what would a juror reasonably be justified in finding standard?
Yes, which would be the current state of the analysis of this issue.
The fact-based one.
Yes.
That's the problem, really, is that the 5202C erects a legal fiction. I mean, in fact, a legal fiction that's contrary to fact, not just imagining something to exist because of the imagining something the opposite of what actually exists. And it makes it hard. I think it interferes with our
analysis up till this point on lesser included instructions.
It does complicate the analysis, certainly. The state would argue, nevertheless, that even if this court were to find that there was error in not issuing this instruction, that it would necessarily need to move on to the harmlessness inquiry and determine whether there's a reasonable, obviously, possibility that the jury would have convicted. And when we look at that analysis, the state would be on board with what opposing counsel has submitted, which is start with looking at this through the skip rule lens. But where I would part ways with counsel is he argues that the jury considered intentional against intentional. And what the jury considered was premeditated intentional against intentional. And the jury found that premeditated component over merely an intentional act. And when the jury had that lesser included offense to consider and found that it was more than a merely intentional act, that it is not likely that the jury would have found for an even further lesser offense of it being merely a reckless act. Therefore, there would not be error in refusing to issue this instruction. Moreover, the state would direct this court's attention to the overwhelming evidence of premeditation that, again, we have 3 individuals that armed themselves, drove to this apartment, climbed the stairs to get to the defendant's apartment, surrounded the entrance and the exit to that apartment, and fired multiple shots in the crossfire fashion, left him there to die but then also turned around and fired 3 more shots just for good measure from the stairwell into the apartment. The district court's refusal to give the instruction was proper in this case in that it was not factually supported. If there are no further questions, the state would submit the remainder of the issues on the brief and would respectfully request that the defendant's convictions and sentence be affirmed.
Thank you, counsel. Mr. Kittle, you reserved 3 minutes.
First, Justice Breyer, you asked a question about where the victim whether they were seated and whether there was blood in different areas. My recollection of watching the video is that I know the body was found, and where it's first seen is lying on the floor in the kitchen. And there's blood everywhere in the kitchen. But at some point, emergency personnel actually pick up the body and move it into the living area after the shooting. So I'm not sure whether if there was blood found in that area, it may have been taken there after the fact.
Okay.
What do we know from the record? We know that the jury was instructed to find the defendant guilty of, in count 2, of criminal discharge of a firearm. One of the elements it had to find was reckless conduct. And clearly it found reckless conduct on the part of the defendant. And I realize, as Justice Siegel has described them, these nesting states of mind or levels of culpability. But whether you consider it intentional or reckless, there still is a finding in the record of reckless conduct. And to my mind, that raises the distinct possibility that had the jury been instructed on a reckless form of homicide, it could have reasonably returned a verdict on a reckless form of homicide. Couldn't
they have found the defendant not guilty? If they didn't think the activity was intentional, then intentional wasn't proved beyond a reasonable doubt as an element.
Well, we don't know what the jury thought regarding count 2 other than it found reckless conduct. And sure, the jury could have found him not guilty, I suppose. But in finding him guilty of reckless conduct for discharging a firearm, which basically is what it was, and because the victim was killed because of the discharge of a firearm, it's a possibility that the jury could have concluded the victim's death is caused by a reckless act, the discharge of a firearm. And we don't need to engage in speculation about what the jury might have thought about culpable state of mind regarding the count 2 of the complaint, because we know what the jury found. It found reckless conduct. That's all it had to find. That was specifically what it was asked to find, and we know that's what it did
But I
find.
think the question was, if the jury did as you're suggesting, wouldn't the jury have acquitted the defendant on the murder charges?
Well, that's possible, but that doesn't change the fact that under the law, the court is obligated and the jury, the defendant is entitled to have an instruction on a crime that is supported factually by the record. And we have that here.
But that does take away your argument that the jury necessarily found only reckless behavior with regard to the discharge of the weapon.
No, because these crimes are separate. The jury's verdict regarding one has nothing to do with the jury's verdict regarding another. What we know from what we have in the record is that the jury found him guilty of reckless conduct with respect to count 2. And that's all we know. To conclude something other than that is just requiring speculation about what the jury did. And we don't have any basis to support any of that speculation. And otherwise, what we have is the state asking this court to consider the facts in the light most favorable to the state to come to the conclusion that the defendant knew or saw someone in the apartment. And we just don't have evidence to support that. Certainly, you don't have that when the proper standard of review is applied. Asking this court to consider the facts in Mr. Randall's favor, which is what the law requires. I'm out of time, so unless the court has other questions.
Any other questions? Okay. Thank you, counsel. And thank you to both counsel for your arguments in this matter. We will now take this case under advisement.